Minister, we need full disclosure and openness from the Government and from those who were in positions of power in relation to the Government's heartless political strategy to withhold and deny disability payments to those in residential care who were entitled to it. Now, this must involve full cooperation and transparency from Government, including acceptance of any requests from committees for ministers to address the matter. The practice by successive governments from the 70s into the 90s was to deny disability allowance payments to those in institutional care, and this affected thousands of people in up to 140 institutional care homes. It has been estimated that this affected somewhere between 4,000 and 10,000 people during the time the payment was made by the Department of Health, and another 2,700 after the Department of Social and Family Affairs took over payments. And many of these people had profound disabilities and would have been reliant on the state to care for them and advocate on their behalf. And instead of advocating for them, the strategy by successive governments has been to conceal and deny, cover up and delay, instead of protecting often extremely vulnerable citizens. A callous and calculated strategy to deny the most vulnerable of their rights. A strategy of paying up to those with the resources to take legal action and punching down on those who did not. These revelations, as shocking as they are, should not come as too big a surprise if we consider the other scandals involving successive governments down through the years, where they have tried to deny people rights by concealing information and settling in the steps of the court. And I am thinking of those affected by thalidomide, those affected by sodium valproate, the cervical check scandal, the mother and babies redress scheme, and of course the nursing home fees. A government memo from 1997 estimated that claims from those affected could be in the region of 350 million to 700 million before taking into account legal costs. In 2006, a case was taken on behalf of a woman who had been receiving a disability payment previous to her admittance to a psychiatric facility in 1983, which had been stopped within weeks of her admittance. The case centred on the claim that the regulations which led to the discontinuation of her disability allowance payment were in conflict with the law, and therefore ultra-vires, meaning they had no legal standing. The case was settled in 2008. So if, as the current Attorney-General concluded yesterday, that the state had no positive legal duty to make retrospective payments on the disabled person's maintenance allowance, then why was this and other cases settled by the state? A further joint memo for Cabinet was prepared in 2009 by then Minister for Health Mary Harney and Minister for Social and Family Affairs Mary Hanafin to assess the potential implication of the case. Two members of the current Cabinet were also members of the Cabinet when this memo was prepared and brought to it. Cabinet for discussion, Micheál Martin, who was Minister for Foreign Affairs, and Eamon Ryan, Minister for Communication, Energy and Natural Resources. And indeed, three other members of the present government were also ministers in 2009 when this memo was prepared for Cabinet. We had Willie O'Dea, Eamon O'Keefe and Brendan Smith. So I'm saying, do they stand over the denial of these payments? And do they stand over the strategy to conceal, deny, cover up and delay instead of protecting vulnerable citizens? In 2011, when the Fianna Fáil Green Party coalition was replaced by Fine Gael and Labour, another brief was prepared on this issue. In the Dáil last week, the Taoiseach said that the legal advice regarding the disability allowance was that the state did not have a leg to stand on. How does this now square with the conclusion of the Attorney-General? The Taoiseach is reported in the press as having said that the government will do whatever is legally required and morally just. Will the government now do that?
I would like to thank Deputy Tully genuinely for raising this matter. From the outset, I want to take the opportunity to set out the context for what is an extremely important issue that many people have been familiar with over the last number of days and indeed weeks. Disabled persons' maintenance allowance constituted a weekly allowance paid by health boards to persons who are unable to work by reason of a disability. The scheme was first introduced under the Health Act 1953 and remained under the responsibility of the Minister of Health, the health boards and the HSC for over 40 years. Responsibility for the payment and administration of this allowance transferred to what is now the Department of Social Protection in 1996. At that point, the disabled person's maintenance allowance was discontinued and replaced by disability allowance. I should clarify that the legal concerns around the operation of this payment primarily relate to the period before the scheme transferred to the Department of Social Protection in 1996. Furthermore, since 1999, people entering nursing homes have retained their entitlement to disability allowance, and since the start of 2007, eligibility to full-rate disability allowance was extended to all people in a care setting. As such, these issues are historical and relate to arrangements that have not been in place for many years. In response to public concerns, the Government asked the Attorney-General to review the files in the Attorney-General's office regarding charges levied for the provision of nursing home care and the non-payment of the disabled person's maintenance allowance to persons in residential care, and to provide an account of the litigation management strategy adopted by the State insofar as it was based upon the legal advices provided by previous Attorneys-General and the Office of the Attorney-General. Yesterday, the Government noted the report from the Attorney-General on these matters. The report is now being laid before the Houses of the Oireachtas and published. The report analyses the nature of the State's approach to civil litigation and provides an explanation of the litigation process. The report considers the disabled person's maintenance allowance and the historical question of the legal authority to withhold payment of the allowance to persons in full-time residential care funded or part-funded by the State, and litigation relating to non-payment of the allowance. It confirms that there was no positive legal duty to make retrospective payments. Yesterday, the Government asked the Minister for Health, Stephen Donnelly, and the Minister for Social Protection, Heather Humphreys, to consider the report and revert to Government within 3 months. As the Taoiseach said today, the two ministers will look at the report in the round. There are a lot of documents to consider dating back to the 70s and 80s, and that is why it is important that adequate time is given to consider the issues at hand. Furthermore, the report by the Attorney-General will be discussed in the Dáil tomorrow by members from all sides of the House, and it will also be considered by the relevant Oireachtas committee. I think it is important, however, that we do not provide mixed messages on this Government support for people with disabilities. In Budget 2023, a number of important supports were brought forward for people with disabilities, including a cost of living double payment, a €500 cost of living disability support grant, a Christmas bonus double payment paid in December, a €12 increase in weekly payments with proportionate increases for qualified adults. Domiciliary care allowance was increased by €20.50 to €330 per month. And these are just some of the few measures built on a range of supports provided over successive budgets. I want to assure the House that the Government remains committed and ambitious in its support for people with disabilities.
The Taoiseach stated that while the Government has a responsibility to do what's right, it has a responsibility to protect the taxpayer. Now, I note that Minister Roderick O'Gorman was speaking on Morning Ireland, and he stated that the need to protect state resources had obscured the need to protect the vulnerable. And I quote when he said, "The state is subject to legal actions when it adopts legal positions. I think it's really important that those positions are influenced by the obligation that the state has to some of its most vulnerable citizens." And that's the approach I would urge. But I'm just at odds about that I just feel this is not about protecting public money. Because if we look at it, the state did not fight the church in court to get it to pay for all the abuse that it inflicted on children. It did not fight the suppliers of faulty cement blocks or the builders of shoddy apartments for their mistakes, or negligence, I should say. It did not make them pay. The taxpayer shouldered the burden in those instances. So I just feel the state won't make the strong pay. Wherever you're vulnerable or poor, you are deceived and you are robbed. Now, I also want to remind you that this state signed up to the UNCRPD in 2018, and we should be bound by the commitments within that convention. So I'm hoping that the two ministers will be guided by what's in the UNCRPD when they carry out the review. And just to speak of a couple of articles of that, Article 12 states that persons with disabilities should be given the support they require in exercising their legal capacity. Article 13, that persons with disabilities should ensure effective access to justice on an equal basis with others. They have a right to information. Right for persons with disabilities in Article 28 to social protection and to the enjoyment of that right without discrimination on the basis of disability, and the state should take appropriate steps to safeguard and promote the realisation of this right. That was denied to those people. And I know the UNCRPD was only signed in 2018. Really, we have an obligation to live up to its commitments now that we have signed it and ratified it. Thank you.
I'd just like to go to your initial response there, Deputy, and I think it's very important to make the point that, as the Attorney-General points out in his report, it is sometimes tempting to resort to generic stereotypes about the state being in some way unfair to its citizens, where they are deprived of benefit, and bring legal proceedings challenging this deprivation. But the logic of such a perspective is that the state has unlimited resources, must concede every court case that is brought against it, and must fund every claim for compensation or redress that is demanded of it. The fact that citizens have a legal entitlement to challenge decisions of the state before an independent judiciary does not imply that all of those challenges are well-founded or that the state is not entitled to defend itself against a legal challenge. Governments must make hard choices all the time, with finite resources and the requirement to defend litigation that seeks to challenge those choices inevitably follows. I think it is important to take the opportunity to once again emphasise that these issues are historical. Over the period of 1999 to 2007, entitlement to full disability allowance was gradually extended by the governments of the time to people resident in institutional care settings. This shows that successive governments sought to expand access and funding in a progressive manner. The track record of the government over recent budgets shows that we have taken concrete steps to support people with disabilities. I want to assure the House that this remains a firm government priority. The Minister for Health and Minister for Social Protection will now consider the report and revert to government within 3 months. And I do thank the Deputy for raising this matter and look forward to engaging with her and others more on this issue in due course.